Principles of Administrative Law. Introduction. Administrative law is the branch of public law that regulates the powers and functions of administrative authorities. Its purpose is to prevent abuse of power, protect individual rights, and ensure that government acts within legal limits. Over time, courts have evolved certain principles and doctrines which form the foundation of administrative law. Judicial review. Courts hold the ultimate power to review administrative actions. They will strike down any decision that is ultra vires, beyond its power, disproportionate, excessive, or unreasonable. Safeguards against arbitrary discretion. Courts ensure that administrative authorities act within the law. Focuses on legality, lawfulness, not the merits of decisions. Controls discretionary powers to prevent arbitrariness. Grounds: illegality, irrationality, procedural impropriety. Rule of law. No administrative authority is above the law. Every government action must have clear legal backing and cannot be based on arbitrary personal whims. The concept of the rule of law, popularized by A.V. Dicey, forms the bedrock of administrative law. It mandates that governance must be conducted according to established legal rules, not arbitrary individual will. Dicey's three core postulates: supremacy of law, absolute power of regular law, absence of arbitrary executive power, equality before law. No one is above the law. Ordinary citizens and government officials are subject to the same ordinary courts. Predominance of legal spirit. Rights are protected through judicial enforcement. Constitutional framework in India. Article 14. Equality before law and protection against arbitrary state action. Article 19. Protection of core freedoms against unreasonable restrictions. Article 21. Deprivation of life or personal liberty must follow a procedure that is just, fair, and reasonable. Articles 32 and 226. Constitutional writ remedies to enforce legal limits on the administration. Key case laws. Somraj v. State of Haryana. Administrative discretion must be regulated and guided by law, not uncontrolled personal discretion. Menka Gandhi v. Union of India. 1978. Any administrative procedure must be fair, just, and reasonable to satisfy Articles 14 and 21. Indira Nehru Gandhi v. Raj Narain. 1975. The rule of law is part of the basic structure of the Indian Constitution and cannot be abrogated, even by constitutional amendment. Doctrine of separation of powers. To prevent tyranny, the executive branch cannot usurp the powers of the legislature, making laws, or the judiciary, settling disputes, without strict legal limits. Propounded by Montesquieu. Legislature makes laws, executive implements, judiciary adjudicates. India follows functional separation with checks and balances. Case: Ram Javaya Kapoor v. State of Punjab. 1955. Principles of natural justice. Decisions must be made fairly. This requires an impartial judge free from bias, nemo judex, and a fair opportunity for the affected person to be heard. Audi alterum partem. Justice should not only be done but seen to be done. The three core pillars of natural justice. Modern administrative law bases natural justice on three essential pillars. Nemo judex in causa sua. Rule against bias. This rule translates to, no one should be a judge in their own cause. It demands that the deciding authority must be completely impartial and neutral. Justice must not only be done but must manifestly be seen to be done. There are 4 recognized types of bias that can disqualify a decision maker. Personal bias. The judge has a personal relationship friendship, or hostility toward one of the parties. Pecuniary, financial, bias. The judge has a monetary or financial stake in the outcome of the case. Any financial interest, no matter how small, automatically invalidates the proceeding. Subject matter bias. The judge has a direct interest in the topic under discussion, or has already expressed a strong, unyielding public opinion on it before hearing the case. Departmental bias. The official investigating a matter or prosecuting the case is the same person making the final decision, often a challenge in internal government department inquiries. 2. Audi alteram partem. Here the other side. This rule translates to, no man should be condemned unheard. It ensures that both sides are given a fair opportunity to present their case before a decision is reached. For a hearing to be considered fair, several procedural elements must be met. Proper notice. The affected person must receive clear notice stating the charges, facts, and the time, place of the hearing well in advance. Right to present evidence. The individual must be allowed to present witnesses, documents, and arguments in their defense. Right to rebut evidence. The individual must be given access to the evidence being used against them so they can challenge it or cross-examine opposing witnesses. Right to legal representation. Depending on the complexity and seriousness of the case, the right to be represented by a lawyer may be granted. Reasoned decisions. Speaking orders. A modern addition to the core pillars requires that the deciding authority must state clear reasons for its decision. A decision with reasons is called a speaking order because it explains the mind of the judge. It prevents arbitrary decision making. It ensures the judge applied their mind to the facts and evidence. It allows the affected individual to understand why they lost, making it possible to file an effective appeal in a higher court. Exceptions to natural justice. The principles of natural justice are flexible and can be excluded or modified under exceptional circumstances, including statutory exclusion. When an explicit act of Parliament clearly rules out the application of natural justice. Emergency situations. In matters of national security, public safety, or public health where immediate preventive action is required, e.g., demolishing a structurally unsafe building or quarantine orders. Interim disciplinary action. Temporary measures, like suspending an employee pending a full inquiry, do not always require a prior hearing. Academic evaluation. Academic grading or internal marking assessments by universities generally do not require a formal hearing. Doctrine of ultra vires. The doctrine of ultra vires means, beyond powers. It states that an administrative authority cannot act outside the legal boundaries set by law. Any action that exceeds these powers is void, illegal, and unenforceable. Breakdown. Substantive ultra vires. The authority does something it has no legal right to do. E.g., a local traffic department tries to change national income tax rules. Procedural ultra vires. The authority has the power, but fails to follow the mandatory procedure required by law. E.g., passing a rule without a mandatory public notice. Abuse of power. Even if technically legal, an action is ultra vires if done in bad faith, mala fides, for the wrong purpose, or based on completely irrelevant facts. Core purpose. It allows courts to use judicial review to strike down arbitrary government actions and protect citizen rights. Chintaman Rao v. State of Madhya Pradesh. The facts. A local law authorized a district magistrate to ban the manufacture of bidis, local cigarettes, during the agricultural season to ensure enough labor for farming. The magistrate used this power to issue a total ban on all citizens in the area from making bids. The ruling. The Supreme Court of India struck down the order. The court held that the legislature intended only to balance labor supply. But the executive completely banned a lawful business altogether. Why it matters? This is a classic example of substantive ultra vires. The official exceeded the exact scope of the enabling law and created an arbitrary restriction. Writs used against ultra vires actions. When a government authority acts ultra vires, citizens can file a petition in a high court or the Supreme Court demanding specific constitutional orders called writs. Writ of certiorari. To quash. The court reviews a decision already made by a lower tribunal or agency. If the action is found to be ultra vires, the court completely cancels and voids it. Writ of mandamus. To command. If an official acts ultra vires by refusing to perform a duty they are legally obligated to do, the court commands them to fulfill their legal job. Writ of prohibition. To stop. If an administrative agency or tribunal is in the middle of handling a case that is clearly outside its legal jurisdiction, a higher court steps in to freeze the proceedings immediately. The doctrine of proportionality means that the punishment or administrative action must fit the nature and gravity of the offense. It ensures that the government does not use excessive or overly harsh methods to achieve its goals. An easy analogy is, you cannot use a sledgehammer to crack a nut. Courts use this doctrine to actively balance public interest against individual freedoms. A classic example is the Mrjsbhatti case, where the Supreme Court ruled that an indefinite internet shutdown was an excessive, unproportional response to security concerns. The four-step test of proportionality. For a government action to be considered proportional, it must pass four strict tests. Legitimate goal. The restriction must serve a valid public purpose, e.g., public safety, health, rational connection. The method chosen must actually help achieve that goal. Least restrictive means. The government must choose the option that causes the least amount of harm or interference to citizen rights. Balancing. Proportionality stricto sensu. The benefit to the public must outweigh the damage done to the individual's rights. Landmark example. Mrjsbhatti, Union of India. 2020. The case. The government imposed an indefinite blanket internet shutdown in Jammu and Kashmir to maintain national security. The ruling. The Supreme Court of India held that while national security is vital, an indefinite internet ban is a severe violation of freedom of speech and trade. The court ruled that restrictions must be proportional, temporary, and limited only to specific areas where danger is imminent, rather than a total blackout. Difference. Proportionality vs. Mrjsbhatti unreasonableness. Mrjsbhatti unreasonableness. The court only intervenes if an administrative decision is completely absurd or irrational. The court does not look closely at the facts or the decision-making process. Proportionality. The court performs a deeper, proportionality review. It actively balances the government's goals against the citizens' rights to see if a less harmful alternative was available. Doctrine of legitimate expectation. A citizen has a reasonable expectation to be treated fairly or consistently based on past government practices or official policies. Even if they do not have a strict legal right, citizens expect fair treatment when authorities follow consistent practices or promises. Protects procedural and substantive expectations. Case. Food Corporation of India v. Kamdhenu Cattle Feed Industries. 1993. Doctrine of promissory estoppel. The government cannot back out of a promise it made to a citizen if that citizen altered their position, e.g., spent money or started a business based on that promise. Government bound by clear promises if citizens rely on them. Prevents arbitrary withdrawal unless justified by public interest. Case Motilal Padampat Sugar Mills v. State of UP, 1979. Principle of good governance focuses on process, not just outcomes. Features: participatory, accountable, efficient, transparent, inclusive. Rule of law ensures decisions are made fairly and inclusively. Principle of reasonableness. The principle of reasonableness states that government decisions must be logical, rational, and free from arbitrary whims if an administrative action is so absurd or illogical that no sensible person could have ever made it. Courts will strike it down as illegal. Administrative discretion must be logical and fair. Prevents irrational or arbitrary actions. Linked with Article 14 and the Mrjsbhatti test. Principle of non-arbitrariness. Every state action must be logical and justified. If a government decision is based on absolute whim, favoritism, or lack of reason, courts will strike it down under Article 14 of the Constitution. Right to equality. Rule against delegation. Delegatus non potest delegare. An authority that has been given a specific power by the legislature cannot delegate that power to someone else, unless the original law explicitly allows it. Doctrine of public accountability. Public officials hold power as trustees of the public. If they abuse their power or cause loss to the public exchequer through gross negligence, they can be held personally liable.